and I'm defrosting from the weather. We were out in the rain for a little extra time than I would have liked, but we're good. We're good. I'm here with Al Hines right now. I was gonna try and get some administrative work done so that, because as you know, I'm trying to still plug in my show. And I saw your messages. Are we on live?
Yeah, we're on live. Go ahead and promote where your show is and all that kind of stuff first, and then we'll move into what all happened today out there at the courts.
Roger that. Okay, well, the show is called The Oath with Staff Sergeant Moe. I have a problem with my phone. I'll have to unplug it. The Oath with Staff Sergeant Moe. You can find me, first of all, on Facebook at Maureen Peltier. And then The Oath with Staff Sergeant Moe has its own page, too. And in the descriptions and about is where you'll find the YouTube link to the show, which we're still working on the administrative portion to get me going live on my own show. And some other account, I'm trying to set it up with the conference thing and everything so I can get the show going with good quality. But we are almost there. Well, we're really able to go live if we want at any time. But I'm trying to do a good, conference.
Well, if you need any help, just let me know. I've been doing this for 5 years. If you need any assistance, just let me know. I can help you out, okay?
Thank you, sweetie. I got Al here. He's probably going to help me plug away at some more administrative work tonight. But anyways, yeah. And then I got rid of PayPal because they restricted my account for, it's been 3 weeks, and I've complied to almost every resolution, actually every single resolution that they asked for. And then they went right back to the very beginning with, questions about what kind of business I run and stuff, which I had already explained to them in the very beginning. And then on the third time, they wanted me to, they got really invasive. They wanted my social security number and all kinds of things. So, I figured, what, the FBI is probably behind this and you guys are fired. So I got rid of PayPal, and the only way to receive donations now is through the Facebook private message center, where you can actually, there's like a way to receive or make payments in the private message center. And I have a description that shows how to do that. And then I set up a PO box last night. I still have to sign, I forgot what the form's called, 158 or something like that. I forgot. I have to print it out when I get home this weekend and sign it, and then go get it notarized by my bank and turn it in. And then I'll be able to receive any mail, cards, letters, donations. So that's up and running. So as you can see, I'm just plugging away at all the different aspects.
It kind of becomes a pain in the butt. Yeah, PayPal did that to me way back in the beginning. Basically, I run everything everything I have, my farm, everything through PayPal. So they're getting enough fees; they don't care.
No, yeah. Yeah, there's actually, when I'm not the only one too, I noticed that they're attacking a lot of people in the Patriot community, specifically starting to target them now. So I don't really have much good to say about them any longer. But I will be looking for another app too for a crowdfunding situation that's inexpensive to zero fees. Similar, I'm getting a lot of recommendations in, so I'll still get a third easy donation. I'll make sure it's easy for people, so it only takes them a moment. But anyways, yeah, I'm just plugging away at those things. But today was court, as you know. First off, at the second part of the day at 1:30 p.m., Jason Blumgren, he had a court appearance for his arraignment finally, here in Portland at least. And he, let's see here, what do you call them again? Pre-trial personnel recommends his release based off of the plan that they provided, pre-trial services. And he received that. The government, of course, made their best attempt, which was, again, feeble, at citing that, let's see here, the CR 51 case in Brown with Judge Brown should proceed, but the CR 64 with Judge Jones is probably going to be dismissed. And then he was arraigned today earlier on the preliminary hearings for the superseding indictments that are coming up. Judge Park says that the CR 64 case is still alive and needs to be entered in some sort of order, but he understands it will be fully dismissed. And then the pretrial services made their recommendation for release, and he conceded to that at court, with the father, Jason Blumgren's father, as the person chosen for custody. The pretrial services denied any of the supporters that were there. Several volunteers stood up when they got the phone call, when we got the call from the attorneys, stood up and said that they would take Jason and take him to his parents' house in North Carolina, because his parents are both elderly and of ill health. And so people did volunteer to provide a better plan than putting his father out that way, especially when his parents are also taking care of his two boys right now. So it's very complex to have his father come get him, but the pretrial services said, no, we'll release him under that condition with his father getting him. And of course, they gave him other conditions as far as, he'll have to remain put in the home, and he'll have his bracelet on, his ankle bracelet, things like that. And so before the judge ruled on it, the government then did its prosecution monologue, talking about how they have a photo of him holding a long gun. Ooh, scary stuff. And, the photo, I've seen it before online. We all have. It's him just posing, not brandishing, posing. And, I was thinking about that, and I hope all the attorneys, I'm trying to spread the word. I've already told one investigator, one of the attorneys, that it's a really good angle to think about. And this was Daryl Thorne's investigator. A good angle to think about. The truth is, they weren't brandishing weapons because there was nobody there to brandish the weapons at anyways. Federal government never made their way up to them. Neither did local law enforcement. As you know, they were all invited. So I don't know what they were brandishing their weapons at. And this is separate from the Clive and Bundy event at the Bundy Ranch. This is just the Oregon. I'm just speaking directly about Oregon. And the only thing that you have the government showing over and over again is photos of them with their weapons, posing. No different than soldiers have photos of us posing with our rifles and AR-15s. That didn't make us a threat. The only threat that a soldier would pose to you is if you shoot at us, we shoot back. It's called a defense. And an ROE overseas, we were on the, we weren't primarily most soldiers, like myself, in combat support roles, were on the defense only if necessary. Otherwise, we're going about our day, trying to get supplies where they need to be. We attack no one unless attacked. But when you see us with our weapons posing and stuff, that's not brandishing a weapon, that's posing. So that's what you see the guys doing a lot. So I brought that point up, and it was a perfect point I just made the other day. And then I hear right away off the bat in court today, the government's talking about a long gun, like it's wrong. And then what else did they say? What did you say, Al? I'm sorry.
You can go on anybody's Facebook page on hunting time.
Oh, yeah.
Find the same thing.
Yeah, you can go on anybody's Facebook page around hunting time or just training on the range. Yep. People who just, for sport or hunting, you can go on their pages all the time, and they're always posing with their weapons, Anyway, so Blumgren says, and you see them smiling and stuff.
Well, yeah, actually, hold on. I got a video taken down the other night because I was demonstrating how to get the piece of crap plastic heat shield off of an AR-15 and put on an aluminum quad rail, and I got my whole video got shut down over that.
Wow. I mean, see how the narrative is changing things from, casual photography with our weapons that we own, we purchase with our hard-earned money, we train with them. It's not only our constitutional right to defend ourselves and bear arms, but we're also usually very proud. They're an extension of yourself of some form. When you've learned to operate them adequately and safely, and you maintain them, and you take pride in that. And usually when we take photos with them, like myself, I was very proud of my weapon. My weapon was my lifesaver, especially out overseas. But then if you're here at home and you're sporting and you're training, you're just proud of the accomplishments. You're zeroing in on your targets, and you're getting tighter and tighter shot groups. And these are things that Americans have always been proud of. Anyway, so the government goes on to say that Um, Jason told the FBI that, you know, there was no bombs or bomb making, but that leadership at one point or maybe on a couple occasions had talked about the possibility of needing to maybe make IEDs. But there was never a plan executed. You know, it was dismissed. And then they talked about the fact that he had obtained a 40 cal Smith & Wesson 40 cal that he had with him at all times. Ooh, you know. They talked about how he said he had a no, or well, they found out that he had a no contact order with his brother once. So this makes him very violent, even though the charges were dropped and the no contact order was dropped, and then it was reduced to keep separate order. And also they mentioned that he had excessive, when they found him and arrested him, he had no weapons on him, but he had excessive ammunition. Wow, you know, and it was just a couple mags, and then some of the items needed for a 40 cal, which he at one time had on him.
You mean the guys that ordered 5.8 billion rounds of hollow point ammunition thought he had excessive ammunition? Okay.
Yeah, those guys that ordered 5.8 billion rounds were saying that Jason Blumgren, when he was arrested, had excessive ammunition, and they only mentioned a couple mags, right? So then the defense came in and he said those pictures of the long guns, or you know, of him, you know, not, you know, he's not brandishing anything at anybody, he isn't acting violent. They also countered and this is the defense speaking, his attorney, what was his attorney's name again, Mr. Rainwater. He had discussed that that he had a concealed weapons. He was registered to carry a weapon and to be concealed from his state. So he wasn't even carrying outside the realms of legalities. He was in complete compliance with the law in order to be able to obtain and retain a weapon. And he talked about his character, that he talked about his family, his sons. He has two sons, one of them having, oh my goodness, words are failing me right now. What was the disease? His son has a disorder. I know what the disorder is. The word is just escaping me right now. My apologies. Autistic? Yeah, no.
Asperger's or autism?
I'm going to go with autism today. I better double. You know, I just feel like uncomfortable with the word, but yeah, I guess that might be, you know what, I think it is. I'm sorry, guys. I'm so tired. But anyways, they talked about that. They talked about his parents being elderly, but that, you know, they talked about when he was home and that he had not been there from the beginning. He left at a later date to go see what was going on and how he can be of help in a peaceful way with no intent to harm anybody. And that he behaved. He didn't get on social media too terribly much, but when he did, he didn't say anything. He was, you know, Joker Jay. He made a lot of silly videos. He talked about, you know, guard duty and security a little bit, but not a lot. And then the judge listened. The government had nothing further, and the judge said, well, I'm going to go ahead and determine to go ahead and release him to go home, but, you know, he has to still attend all his court appointments and things like that. He has no history, no criminal history, nothing for cause for concern to be able to release him. And like I said, pretrial services made a good recommendation on his behalf, and so he decided to go ahead with pretrial services recommendation, and just told him to stay in compliance. And of course, Jason agreed. He asked if the government will appeal or wants a review. Actually, I think the defense kind of pushed to find out if they were going to want that or not, because it was contingent. His release was going to be contingent if the government chose to do an appeal, because they have that right. And the government said, no, they're not going to do any appeal or any review. They'll just go ahead with that and go forward. And And then the other thing is to work on the thing that pretrial services strongly really recommends, and the judge agreed to or conceded to, is that his father is the one that picks him up. So they're trying to make arrangements for him to travel now. On my Facebook page, Maureen Peltier, you will see my very last post immediately after I left court. I was still in the elevator with Victoria Sharp and other great patriots, and I made the video, and I provided Jason Bloomgren's information for his PayPal account and other fundraising, and the P.O. box that they had set up, so to help his father out with the accommodations to get him out here and for him to return flying with his son to bring his son home to his grandchildren. So that is what's happening right now. And I think he is either going to be released in the next 24 to 48 hours.
All right. What about, did they do anything with any of the other guys at all?
No. Let's see here. Let me go back to my notes now for that. I just wanted to get Jason out because we had a little victory. Let me get back to my notes. Sorry. Bear with me, guys. I have a notebook full of notes, and I had to close it.
No problem. You're doing a fantastic job. I've been, I watch you on Facebook and all that. You're very, very busy, I can tell. That's why I don't like trying to cold call you on the air. I want to, say, are you ready? So, You're
so sweet. Yeah, no, you're so sweet. I know it's so hard with me to nail me down sometimes, but I gotcha. March 9, 2016. So here we go. I found my notes. All right. So Judge Anna Brown was presiding. Okay. One of the first things I observed in court, and I'm going to let people know, is, and Blaine showed me his arm. He showed me his arm because it had the bandage. When they draw your blood or put an IV in or something? Well, it looks like they drew his blood, but I also am concerned because he looked tired and fatigued compared to the others, possibly medicated. I haven't had a chance to speak with him yet. Of course, I sent out my pink slips and everything. But and I'm scheduling appointments on the kiosks to see the guys in Inverness, and then I won't be here for the weekend to do visits in person, though, at the Multnomah County Jail. But I am working on the video app, so I can start seeing them on the video app, too. And you can find that link at the Multnomah County Jail inmate directions and instructions. If you all want to get a video app, for $5, you'll get 30 minutes with them, I'm told. So it's pretty good. I'm working on that. That'll save me a lot of time and Uber taxis. Anyways, but I noticed that he was fatigued looking. He looks medicated. I wasn't thrilled with that. And he did show me that bandage, and I don't know what it means because we can't really talk. So maybe his blood was just drawn for some reason. I don't know. Anyways, but moving on, case number 16CR00051. Ethan Knight, the prosecutor, one of his other prosecutors with him was Jeff Barrell, and I didn't catch the other guy's name. The judge had granted a motion, had received, and she granted a motion for, in regards to an indictment being, what was it called? Dismissed. One of the indictments being dismissed. And they didn't state which one. They didn't give a number or which one. So I'm a little confused on that right now. But bear with me. I'll find out some more as I get to talk to attorneys and ask those important questions. They went through a list of the attorneys and their guys. So I have most of the attorneys' names. Again, I only missed a few. They moved quickly through them. Prosecution, Ethan Knight's the one that lists them all. And it's kind of like a roll call, so to speak. Who's in the courtroom, who's waived their right to appear, but the attorney is there, and who's still at a state but but being indicted on specifically case number CR 00051. So they go through all those motions, and then the prosecution put out the indictment. Count 1, impede officers of the U.S. On March 5th or thereabouts of 2015, continued all the way out to January 2016. He names all the defendants again. They did a redacted name too that we're not sure of who that is yet. There's one name that's continuously redacted throughout the charges. They said they did willfully conspire, they intimidated, threatened BLM, other agents, local law enforcement, etc. And also they went into that with regards to the local Harney County individuals and citizens. They said they prevented them from discharging their duties on Title 18 U.S. Code. They committed overt acts. On November 5th, 2015, traveled to Harney County. It was Ammon Bundy and Ryan Payne who traveled to Harney County to warn of extreme civil unrest, to intimidate or coerce the population of Harney County. They brandished firearms. They occupied a federal government building or land. They said that January 2nd, 2016, they brandished weapons on the premises of the refuge. They refused to leave. They threatened violent persons that attempt to come towards them or to remove them. They posed with firearms or firearms on a federal facility, inciting the U.S. Code Section 3.2, Count 3, 924C. And 2 was cited that they aided and abetted by each other, amongst each other, did knowingly carry firearms, and a conspiracy to impede officers, Title 18 U.S. Code 924, C1A and 2, 18 Section 6 and 41. Kenneth Mattenbach, he is still representing himself. He is listening to counsel advice, but he refuses to be represented in the court of law by any attorney. And he's got a separate indictment of count 5 for stealing camera and equipment in the vehicle. Count 6, I don't know what equipment he touched besides the vehicle. That's the first I heard of it. That he's in violation of count 6. All of them.
Was that the guy that took the truck to the Safeway?
Yeah, that's the guy that took the truck to the Safeway.
Okay.
They brought that up, and then all of them were also indicted for count 5 with the cameras and equipment in violation, and count 6 for defamation of U.S. property, and particularly the Paiute tribe damages, maximum penalties. Count 1, 6 years, $250,000, and I'm not even talking about probation afterwards. Count 2, 5 years, $250,000. Count 3, lifetime imprisonment at $500,000.
Hey, hold on a second. Hold on 1 second. I just heard something about Paiute. The
Paiute tribe
artifacts.
Yeah.
I actually have a video, if you go digging in, where they're using a Paiute smudge bowl as a doorstop.
Oh yeah, they have it. The defense has all that. Yep. Yeah, no, it's bullshit. I'm just reading to you what the government is still claiming, even in despite of true facts and evidence that is already made available to the public.
All right, yeah, that's cool. I just, there's just variations here that are that this just turns into more and more. What? Huh? Who?
Yeah.
What, where? And in my head, I'm hearing the theme to the beginning to every Three Stooges video I ever saw.
Yeah, and so exactly. Oh, by the way, I missed something. Back before I was giving you the counts and time in service or sentencing that could be imposed on them, it's for USC 93 Bravo 924 Charlie and US 6541. Count 1 again is 6 years and $250K. That's $250,000 for fines. Count 2 is 5 years and $250,000 in fines. Count 3 is a life imprisonment and $500,000 in fines. Count 4 is for 10 years and $250,000 in fines. Count 5 is and 6 are both also 10 years and $250,000 in fines. So then the judge moved on to what do you plea? in light of these accusations. The plea entry by each defendant, Ammon Bundy, his attorney represented and said not guilty, and he requested the court reading of his rights, despite the fact that they've been read before. The judge noted that for the record, but she stated that I've already given them their rights 3 other times. I don't see it necessary to go over their rights individually yet again in court today. So Ammon simply stated, while he had a moment, he knows that he has no rights. I'll just let that sink in. And that was from Ammon himself. Let's see here. Who was next? Not guilty. The name, Jason. Not guilty. Joe O'Shaughnessy. Arraignment still needs to be scheduled, so his plea's not been entered just yet, because he is dealing with Nevada now, as you know. Ryan Payne, not guilty. Ryan Bundy, not guilty. And then it was announced, shockingly, and this is big news, Ryan Bundy announced he will not accept counsel any longer, and he has decided to represent himself. Ryan Bundy is going to represent himself. Brian Cavalier, not guilty. Shauna Cox, she reserves her rights. She's concerned that she has no rights, and not guilty. Daryl Thorne, not guilty. And it just went on down the list, everybody not guilty from that point on. Some people have arraignment still to work on. It looks like I'm looking to, oh yeah, here we go. Pete Santilli, not guilty. Jason Patrick, reservation of rights. He has a concern that he is guilty, and that he says his rights do not exist. Dwayne Emmer, not guilty. Anderson, what was the first name of Anderson again? Not Sean Anderson, but the other Anderson. I'm sorry, guys. My notes are terrible today. There's the other Anderson. Let me look at my phone really quick. I know. Do you remember it? Oh, my phone battery's dead. What's the other Anderson name? The other Anderson. There's 2 Andersons.
The husband and wife?
No, that's Sean Anderson, but there's another Anderson, a male Anderson.
I'm not sure.
Oh, my phone is off. My brain's dead.
But I'm sure our listeners understand.
Yeah, I know our listeners know. Please forgive me, guys. But he also pleaded not guilty. Sean Anderson also pleaded not guilty. David Fry also not guilty.
Sandy? You talking about Sandy Anderson?
No, but she's next on the list. I'm doing it in order that they did it in court. Okay. There's another Anderson, a male one. Not Sean, but another male Anderson. Anyways, David Fry. Patrick Anderson? No, that's not the name. I know it. It's just evading me right now, guys. Jeff Banta, not guilty. Sandra Anderson, not guilty. Kenneth Madenbach. He said he stood up and said to the court, this court has failed to prove its jurisdiction. And then, as you know, he's representing himself. He has counsel. So the court addressed and said, sir, I'm not accepting those. You'll have to file that in a motion. I'm not accepting that, just citing it. You need to file that in a motion. And Mrs. Schindler, your counsel, will file that for you on your behalf. And then he stated that, the counsel spoke for him after that. They're not prepared to enter a plea. He still is representing himself. And the judge said, okay, these complexity, I understand that is where he stands still, but I'm going to enter a plea for him of not guilty for right now while you guys work on that. Blaine Cooper, not guilty. Wesley Kajar, he's scheduled a separate proceeding. He's not had his arraignment yet, so they're working on a separate proceeding for that. So no plea was entered just yet. Corey LeCue Oma, not guilty. Neil Wampler, he needs to be scheduled still. He has not had his arraignment yet. Jason Blumgren, not guilty. Daryl Thorne, not guilty. Jeff Stanek, not guilty. He reserves his rights. He's concerned that he has any at all. Eric Lee, he filed a separate waiver, but he's not, and I don't know what the waiver is for yet. Oh, no, I know what that's for. I'm sorry. I shouldn't have taken that note. It's nothing special. That was just a waiver for him not to appear in court, as he's just been released, as you all know, the other day. So he wasn't in court, but he was represented in court, and he filed not guilty. Jury trial is now being requested for all, but it's going to be quite a process to put a jury together. So now I'm going to get into the nitty-gritty of how that was going on in court. I went over that. I'm going backwards, it looks like. Oh, that's why. Interruption on my pages. Mrs. Hayes stood up. She's working on the mechanism. It used to be a Melissa Horvath, but now it's going to be a Miss Hayes, one of the attorneys of Ryan Payne, who's going to be working on the mechanism of keeping the information flowing, both the prosecutions and defense side, when they all file motions, that they still confer first before a motion is filed, and show that they did the conferral by filing along with the motion the notes and information for each party's side in regards to conferences and conferrals. and the judge reiterated the necessity of having conferrals before motions are filed. So when things are truly unresolved, then yes, a motion should be filed, but show her that you truly worked on it before, that you did truly confer, that the government is not only, because they've been very much just filing their stuff and not doing really well at conferring. The defense attorneys are constantly conferring with the government, but not getting anything back from the government in a timely and efficient manner. There's still no discoveries, by the way. There's some evidence out there on some CDs that were downloaded, but with like 3,500 pages of information, but the government is still going through it. So referring to the government, they said they did not provide the actual evidence at this time. And this is what Mrs. Hayes put out. Mrs. Hayes put out, the government has not provided actual evidence yet. They refer to their discovery as so much evidence. And they're taking this time using social media to peruse for more evidence and possibly more people to charge. So she accuses the government of abusing the system, basically, and that they're really not necessarily worried about the evidence that they have right now to file in discovery, as they are really looking for more evidence in what they feel is their opinion, because they're aware of them doing this kind of research and work, and primarily all their evidence is coming from social media. She says, we, referring to all defense attorneys, this was a collaborative effort, are not interested in allowing the government to take more time to collect more evidence in the manner that they're doing so. It's not conducive to a speedy trial. They need to basically present what they already have. She's asking Nevada also, she asked the court to inquire and maybe possibly consider making an order that Nevada release clients that have this trial also to attend to, that were already attending to this case first. And then Nevada, as you know, has taken some people, and it's causing a conundrum. So she says these clients need to be here for this and appear here now at the Portland trial for Oregon. And then defendants, I have a little note here in regards. Okay, so defendants that are facing both the Oregon events and the Bundy Ranch events: Joe O'Shaughnessy, Ammon Bundy, Ryan Payne, Ryan Bundy, Brian Cavalier, Pete Santilli, and Blaine Cooper, and something about Travis Cox not present at this time. So he's not really considered part of the case because he's not present at this time. And then there's the redacted name that we don't know who that is. Mrs. Baggio, Amy Baggio, that would be Joe O'Shaughnessy's attorney, She was waiting to hear if Joe will ever be released from Nevada and returned here. So she brought that concern up to the court. And that's being evaluated still in Nevada. She's waiting on a pending answer in regards to that. Somebody had mentioned that Nevada had been filing bits and pieces of a habeas corpus that had been filed and asked the court to prevent them from being moved to Nevada, meaning it looks like Nevada was trying to get everybody to be moved to Nevada. I don't know how the habeas corpus is facilitating that. I'm just kind of parroting some legalese and words that I have yet to fully understand, if you don't mind.
Oh, right. Honestly, if we could get them out, if we could get them all out of Oregon, they would actually fall under at least some kind of bail bond kind of thing in which they could be gotten out of jail.
I think that they're really just trying to split some of them up, and they're not going to move everybody. And so then what they're doing is dividing and conquering in both places.
Yeah, and I'm still wondering why they're being, Guantanamoing these guys, keeping them in, being kept in solitary confinement is cruel and unusual punishment in anybody's case.
Right.
If you're in prison and you get in a big fight or you murder somebody in jail or stab them or whatever, that's one thing, and you end up in solitary confinement. These guys went into solitary confinement from minute one and have not been out of there, and it's cruel and unusual punishment, and it's like they're trying to break their brains.
Well, yeah. Now, hang on, though, too, because she went on to ask the judge for Amy Baggio's concerns, and the judge, Anna Brown, asked the government, are you conceding, or are you... do you have a pending plan in place to move everybody to Nevada, or is Nevada requesting that? Do you anticipate these possibilities? The government says, well, no, Your Honor. He kind of stumbled, but no, there's not a pending plan that I'm aware of. The government doesn't want to cause any additional problems with the court. He can see how already those moved is causing more complexities, and that they had no interest in causing the court more distress and complexity than they're already facing, is what and that's my Mr. Knight, the prosecution, who suddenly seems to care about a speedy trial. Anyway, so the protest site was the defense attorneys. I forgot which one. It was a she. She had brought up the fact that the protest site had no evidence provided that the whole 172, because here's the point in this. The government keeps saying we have so much evidence to prove them. I mean, for goodness sakes, we had 172,000 acres of land that we had to collect this data from. Give us more time, be reasonable. And she's saying, the government's concerns are not valid because that the range that the Patriots moved around in were all walking distance, that they did not certainly ever use 172,000 acres for their standoff or for their protest. It was not even involved. Much of the space was never involved in this occupation. Good point, right? So the government had turned over the scene to BLM before the defense attorneys viewed it. She complained about that, filing a motion. They have the overlapping Nevada indictments and conducting those that are still remain out of state, and reasons that the government gave are just not valid for their complexities when they're making it complex themselves. So basically, the defense attorneys are beginning to call the government out now for all of these plausible violations or abuses or neglect. And you remember, I've recently learned that the prosecution has a duty and a responsibility to ensure due process. They actually have a responsibility to ensure that the defense is not neglected or abused by themselves, the prosecution. Even though the prosecution should have a good, solid case with evidence provided, it's not their responsibility to exaggerate, falsify, or minimize and provide vague evidence. It is their responsibility to do much better than that. So she's calling them out basically for all these acts on the government side. And she asked that the court ensure a speedy trial is acted. The government says evidence is still being processed due to the complexity of the issues. Artifacts and analysis is ongoing. Judge Anna Brown does selective discovery. Yes, that was brought up. Selective discovery was brought up from the defense, citing that they seem to be cherry picking their evidence, and yet they're being vague on who they're accusing. They haven't narrowed the scope down and identified particular defendants. They're blanketing everything in vague terms using selective evidence, evidence that at best is more accusatory and based off presumption, and in some cases just social media. So it's quite interesting. And then the artifacts and analysis is still ongoing, as the government was citing, well, we still have the artifacts analysis. That is still ongoing. It's a long process. And the government says she appreciate. Oh, the government asked, the judge, Anna Brown, asked the government, do you anticipate more charges? The government said it only depends entirely on the analysis of all the evidence. So sure, it's a possibility, Your Honor. The judge said that the desire for all the defendants to join, she moves forward from that answer and says it's a desire for all the defendants to have originally joined their motions, but it seems that there are some that are a little less sure right now. Nobody was named. A motion was filed to sever the joint filing due to a lack of information, though. It wasn't because they didn't want to join their brothers. It's because some of them got smart. And the judge is pretty much laying this out. She didn't say it in these words, but she's saying due to a lack of information and no discoveries. Actually, then the defense attorneys picked up on that as one of their complaints because of the lack of information and that no discoveries have been provided and they have no idea how to proceed. Whether they should be filing jointly together or individually, because they don't even know what they're facing. They don't understand these blanket indictments with no narrow scope and no identified named target for a very specific motion.
Well, not even that. All these guys were arrested without warrant or charges, and the charges were brought later.
Yeah.
When the hell has that ever happened?
Yeah, and the charges are being brought forward, but still without discovery. So how do you answer to that?
Yeah, all these charges that they're talking about and the time they're talking about serving, literally Mandela served less time.
Yeah.
And this is absolutely ridiculous. Before Ted Bundy was sentenced to, death, he served, he was sentenced to less time. Some of the worst criminals in American history have never had the threat of this kind of time that they, that they want to do this to them.
For a moment in court, it got a little scary. She seemed to backtrack on this. Let me take a sip of water. Okay. I should have done that when you were talking, but I was struggling opening the cap. So now the judge moves forward and talks more about the Speedy Trial Act. And as you know before, she was more than encouraging as far as enforcing their inalienable rights to the Speedy Trial Act. But now she provides the court in certain cases, in regards to the 70-day trial act, she cites something, and I didn't get the number of it, so I'll have to look it up. And your listeners, go ahead and Google this, but the 70-day trial act has a provision in there that could cause a speedy trial to be suspended due to severe complexities, significant complexities. So she starts to go into anybody that's in this courtroom can concede, can agree with me that this case, due to the nature of this case, the amount of defendants, the logistics, the amount of evidence still being processed, as cited, and she said 26 defendants, and that a single trial in itself would still be, if we do this in a joint way as a single trial, to do this in a timely manner. It's just, she kept saying things like it's almost impossible. It's just too complicated. Like, this can't be prepared in time for a trial. That we'll even find difficulty putting together a trial. It might take a whole week to put together a trial or longer. She says there just isn't any way, in her word, and I put that in quotations, to conduct a speedy trial. I'm thinking at this point she's saying she's going to take away their right for a speedy trial. It looked like. Now, hold your horses, because she contradicts herself down the road greatly. Now, I've lost confidence, though, okay, because I'm quoting to you one part, and I'm telling you she did contradict herself later in the trial, but it's caused me to lose confidence because she never explained the contradiction. She never explained which way she's going with this. Now, she's pulled out some regulation that cited that there's this paragraph in there that says that you can remove, you can suspend the speedy trial. But then, she didn't ever say that she would actually do that. Al has something. Hang on.
I believe the standard speedy trial is 45 days for cause.
Oh, yeah.
They can extend it to 70 days.
It is 70. The standard is 70. Actually, the whole Speedy Trial Act is written for 70 days. So the suspension, basically, it almost feels that because it's going to be so hard and impossible that, it's almost like she's hinting and indicating this could go into next year. And then she brings up, there's 2 volumes, or I'm sorry, the government brings up that there's 2 volumes of discovery that were released. 3,500 pages long of FBI reports, and there's dozens of warrants and affidavits filed. And then Anna Brown says that the U.S. 3161H6 issues a written order finalizing that finding in regards to setting the trial date still. So she says, so here's my other complexity, and this is where we get into the contradiction. She says, too, we have another huge case coming up in the fall, in September. We really must set the trial date before then. We really can't wait, though, until after the fall, the trial in fall. We have to set these dates early now. I just can't be at all these hearings, presiding over all of them, and certainly the government isn't prepared or interested in providing us the resources necessary for more judges to cover this, which is an assumption, by the way. Nobody asked if the government would actually provide more judges and attorneys and things. It was just, she just made the assumption on the bench. And when you make assumption on the bench like that, once again, that kind of conduct is very questionable to me. And she's not supposed to be making these assumptions. These things should be found out first. Hopefully she will, behind the scenes, find out. But what she's saying in court is losing my confidence. So a trial date, then she goes on, needs to be found due to another trial scheduled in October. That complexity causes this trial to have to be completed before October, she finalizes. And then one trial that's happening right now, it's also going to cause the other attorneys, about 10 of them that are working on this case are on the other case too. So we definitely have some scheduling complexities.
You're breaking up a bit.
How she said, and then somehow this. Here, I'll take the video off. Maybe that'll help. Can you hear me?
Yeah, I can still hear you.
I took the video off. Maybe that'll help.
Okay, go ahead.
So she says we need to find a week more to pick a jury. Okay, we need a week or more to pick the jury. The judge sees the need to set the date so that they can defer. April hearing is what she's looking at. We'll set a date in April for a trial. She's looking at the first Wednesday of April to be the hearing that will set the date. That would be April 6th, the first Wednesday of April, where they should have a hearing in order to set the trial date. If there is an earlier trial date that is requested, she said the act will be honored. And then she said to everybody, think about your hypothetical projections and how long a trial may occur if you, could be, if you separate from some of the motions and so on and so forth, and how long that trial could be. So plan ahead for the jury pool. And this is where in my notes I wrote to myself, we need to spread the word about jury nullification. We need to educate people about jury nullification. It is time now to really hit on that topic, get our information out there in regards to and funding a campaign for bulk mailings of constitutions of a jury nullification and rules. We need to work really, really hard at presenting that. And I think that with the Finicum family's media platform and help, us independent media and citizen journalists alike can coordinate some media efforts and education provisions, as well as working together on a campaign, a coordinated effort to educate the population about jury nullification. So I just wanted that's from my own notes.
That's cool. You can turn your video on. It was actually a local network problem that I fixed. You can turn your video back on if you like.
Okay. Hi.
All right. Anyway, so now let's turn back to brass tacks. I released earlier today interview with Eamon Bundy, Mrs. Finicum, a couple of those, and and then yesterday I did the same thing, with the Lavoie or Shauna Cox's video, which they say is the whole video. It's obviously not the whole video. There's a whole bunch of time missing from the beginning and a whole bunch of time missing from the end. And they keep picking and choosing what they want to release. And everybody that is putting FOIA requests in are getting denied. So, I mean, what's your opinion on all that?
Oh, the selective release of information. I'm sorry, my notes were distracting me. Is that what you're asking me? My opinion?
Yeah. It's been very selective in the release of the information, and and we had Mrs. Finicum on earlier, and all these other people, and.
Oh, now okay, everything came back to me. I'm tracking. Sorry. Yeah. Okay, so the release of the videos, the time editing issues and concerns, the transparency is lacking. They definitely are caught in a lie right now when it comes to the extra shots fired. There's definitely an investigation. Now, I want to touch on that because that was brought up in court today. Michael Arnold, Ammon Bundy's attorneys, brought that forward to the court, and they said, it's amazing, that the FBI can, it's national. He told the court, this is national news now that the FBI is being found with misconduct and guilty of certain errors, and it has a chilling effect that there's some sort of prejudice or form of prejudice that they would be willing to conduct themselves in such a way. What else basically are they being truthful about anything, especially with the exaggerations, the vague rhetoric filed in the indictments, the blanket effect, the lack of narrowing the scope and identifying particular members of particular crimes, instead just blanketing everybody for everything, when in fact, everybody had a different role, or, it just makes little sense. So he did touch on that. And my personal opinion is, the bottom line is, we can see, we're smart people. The jury is made of people like you and me. And for us, this is evidence now. We're getting the evidence now before trial even starts. And so the release of these little bits of information isn't helping the federal government. The federal government it's to its own detriment that they conduct themselves with little honesty, with no transparency, and they're conducting themselves with that little bit of information and still getting caught in lies.
Well, yeah, it's almost as if they forgot the internet exists, because we're all watching, we're all paying attention. Mrs. Finicum, she verified today that he was shot 3 times in the back. So a lot of those conspiracy theories about being shot in the head are gone, and I can personally put that to rest, because I had some video that really looked like they came up at the end and put him down. So now I can drop that. But still, it doesn't make any difference. No,
and the fact that the federal agents were under investigation and they withheld that, and within that investigation is the actual trigger pullers, is the actual personnel that conducted the murder of Lavoie, and the fact that they're withholding that information, and that in itself is what triggered the investigation against the FBI. They did this to themselves. And what else are they hiding? What else are they burying? What else are they lying about? What else are they willing to persecute these men and women? And how far are they willing to go to persecute these men and women and men in order to sell their lie, their narrative? How
we already know that answer.
Yes, we do.
Ruby Ridge, Waco, and anything like it.
Yes, and the defense attorney touches on those things. So going back to Michael Arnold, there's a huge concern. Now, he was preparing to discuss a motion that was filed, but it contained the name of one of the local officials, and it concealed that name, and he was actually afraid to move forward in court with the public there due to the fact that he says, when we talk about these discoveries, our discoveries, the defense's discovery, it has a chilling effect on our First Amendment. It appears that anything that someone says is being misconstrued now. Anything is being misperceived and misconstrued and used against them. And words are being turned into criminal acts when, in fact, there is none. So he had a personal concern, his defense team, and so did all the other defense attorneys, to move forward with their own discovery, the fact that it had the name of an official. And eventually the judge asked the government if they would like to move forward with him mentioning the name of the official, even with the public there, or not. So he said, well, I haven't seen it, Your Honor. He acted as if he'd never seen it. And she said, well, go on over there with Mr. Michael Arnold now and go see what he has in his hands now. Go see it now and then tell me what you think. So he did. And then he came back. He goes, well, I haven't read everything, but, I'm not sure what his point is. But go ahead. He can go ahead and move forward and reveal that. I don't care, basically. So he went on and discussed his ability, that this was affecting his ability to properly defend Mr. Bundy. I forgot to tell you that. But he discussed the incident with David Ward. Sheriff David Ward's parents, when Mr. Bundy and Mr. Payne, Ryan Payne, first came to Harney County, and they were handing out educational information and pamphlets. And some patriot at some point said something along the lines of, your sheriff what were the words that used in court again? I didn't take the note. Your sheriff should be recused or recuse himself or be removed, something along those lines. And so the parents of Sheriff Ward came back and basically threatened the Patriots, threatened them, saying that you touch a hair on his head, you get near, even though the Patriots never said they would bring harm, they would never bring harm to David Ward. They took the legal speak that the Patriots were using, legal words about how he doesn't belong there as sheriff any longer. They took that as a physical threat in their mind, which you and I know wasn't a threat. You and I know this. They know this too, but they decided to pretend to perceive so. And I'm giving you a lot of my own conjecture here, obviously. I'm filling in some blanks. They decided to pretend to perceive a threat for their son, David Ward, Sheriff David, and they proceeded to justify their own threat. And they threatened Ryan Bundy and the Patriots there that if you touch a hair on his head, we have, what was the weapon they had of choice?
4570.
We have a 470. And it will leave a big hole in you. If you know what that is, it'll leave a very big hole in you. So that threat was made by David Ward's parents. Linda Ward and where's the name to the father? I think.
All right, well, hold on a minute, because between, I went up to FBI.gov/Portland and looked today, and I released this article today that in between the LaBoy-Finicum first conference and the conference yesterday, there is another article about where the FBI put a guy up in prison for 18 months for, talking smack on YouTube. Or, excuse me, talking smack on Facebook. So,
there's a protective order that the government is requesting, a protective order to prevent, I don't know who. They didn't name, they didn't have a target. They filed a protective order with no name.
They have 2 discs.
Two discs with information from social media.
Officers' testimony, officer statements.
Officer statements.
Affidavits and investigations that they've conducted from witness testimony and whatnot. And they have a blanket order to not release those names and that information to the public.
They have a blanket order to not release those names and information to the public because of threats that various individuals, so that the Patriot community made. Yet, the evidence doesn't show that. So the defense asked that the judge, the defense asked that the judge order that the government narrow its scope and identify who's making these threats and allow us to provide discovery of whether they are or not. Provide us discovery, because we're hearing that there's all this evidence of threats, yet we're not seeing anything produced.
And that's why Arnold brought up the fact that there was the other side.
And that's why Ammon Bundy's attorney, Michael Arnold, brought up the example of what occurred with real threats, tangible with evidence and names. And the court allowed that example to come through. That the threats that are being made, if anybody needs a protective order, it's the Patriot community from all the haters out there. As you know, from the very beginning of this, before even the Hammond rally began, online attacks amassed from the opposition, and it's gotten worse. It certainly heightened when LaBoy-Finicum was killed, and they felt that everybody should be killed, and it's too bad nobody else died with him, they said. You've seen all the statements. So the concern that the defense has is the threats, the real tangible threats, can be shown, yes, but that the oppositional side and conflict of interest from government officials and their family members are the ones making the threats. So
I have never seen a threat from anybody but the federal government at this point.
Yeah, and that brought up the fact that there were some people receiving threats via email and things like that, and Ryan Payne brought that up, that point up to his Patriot friend, his brother, citing that, that's the FBI making those threats to you. So, you know, they just went on and continued and carried on with their mission there without fear. So John's attorney also got up making the example. He has a new attorney, by the way, a female. I wrote her name down somewhere else when I got it from his mom. I'll get that to the audience later here down the road. He has a new attorney. It's a third attorney, a final attorney, and she's good. She's really good. So he's in good hands now. This is a blessing. John's attorney, she showed evidence, citing another discrepancy from the government, who in his release hearing held him because they were concerned that the threats, without evidence, but they were told by the government that John was identified as making threats to one of the Harney County individuals at the Safeway. And he was identified by that, but now this new attorney said, I have receipts that show, and his bank records and store records that shows he was not there, but that he was in Arizona, not at the Safeway, not in the Burns, and it's already proved. This proves three possibilities: that the witness, the so-called witness, either lied. They didn't say the witness lied, but they said either three things are happening here, Your Honor, that we would like you to consider. Either the witness is lying, or the witness misidentified, or the third possibility, and Michael Arnold stood up separately and provided the third possibility, which was agreed between all the defense attorneys, which is, it's been known that the FBI agents have dressed like the militia and gone in and acted in such a way with misconduct in order for the public view to be changed. So the third possibility is that it was FBI dressed as a militia type people making these false threats. So that's the third possibility. And so they were able to show on the record and prove that John was innocent of the Safeway event. That never occurred because he wasn't even in town. And then the judge shockingly acted as if she didn't understand how this bared any weight. That was the response to that from the judge. How does this bear really any weight? Well, they regurgitated how it bared weight. That, you know, I mean, you have the government lying and not providing good evidence, and also carrying on in this fashion. That's how it bears weight, and it bears weight because you already have one man who's being held still, not been allowed release based off that Safeway event, which was a lie, or a misidentification, or the FBI set it up to look like that, and John wasn't even in town. Good job. So, something about the judge saying, thou shalt not disclose which is sealed, is some sort of law they were going over. My notes are terrible on it. Can you remember, Al?
Yeah, that was when they're arguing about the protection order.
Oh, the protection order.
Basically, anything that's not sealed should be able to be disclosed to the public.
Yeah, anything that's not sealed should be disclosed to the public. And those, yeah. So you have the protective order being, yep, here's my notes. I did better on my second paragraph. The protective order is not acceptable. It must be revised, she said. So basically, they filed a very poorly produced protective order. So she conceded in the court that it has to be revised, that they need to be more specific and targeted, and identify those that specifically conducted themselves in a threatening manner. They need to narrow their scope, and they need to get that in 2 weeks from today. 2 weeks from today, they have to have that in. So they need to identify the perpetrator and show evidence 2 weeks from today in order to continue on with that protective order, or she's going to disclose it. Judge says there will be a protective order, though, but you guys need to, because she feels that there may be evidence. I don't know what she's talking about, but she says there needs to be a balance of risks and a balance of sharing. So that's how she ended that one. Maybe the protective order will be for the Patriot community, though, based off the evidence of them threatening all of us all the time. I'm just saying.
You know, my big question right now is, all right, we'll get a lot more people look at this video later, but you know, when there was all of this certain death, blood, and end of life, you know, we were looking at thousands and thousands of live stream viewers, and right now I got what, 80, and this is an important topic that we're trying to cover right now. Now, we're going to get a lot more later, but, you know, when I archive this, but still, why are so few people actually paying any attention to any of what is going on right now? And it befuddles me.
Yeah. I don't know.
I'm home sharing it on 15 different group sites.
Yeah, he's on 15 different group sites stealing it from you, he said. Al was joking. He's stealing your audience from you on 15 different group sites. He's disseminating my stuff too. But
okay.
On my page right after we're done here with this show, I'll be putting this up on my page, and I'm going to tag everybody because this was a unprecedented hearing once again, as you can see with all the information I'm sharing with you. And I am just about done. I only have a little bit left to touch on, if you don't mind me wrapping that up real quick, and then the show is all.
Oh, no, go ahead. And then I want to talk a little bit about that video yesterday that was released from Shona Cox.
Perfect. The obligation is for the defense to provide discovery, but the defense says isn't the burden on the government to show us discovery. So in order for us to show discovery, we need to know what we're showing discovery on. And that was Amy Baggio again talking. So joint statements that need to be filed with better identification, also narrowing the scope of discovery, will also be expected by the defense. Judge asks for a reasonable plan for the joint effort to clear way to assure production on a good mechanism is in place. So again, she reiterates what she already said in the preliminary hearing on the 24th of February. So approving acquisitions from third party without retribution. That's something Michael Arnold brought to the attention of the court, that he and the other defense attorneys are often being provided good information from third parties through social media, so on and so forth. And they want to make sure that retribution is not brought onto them, also, again, hindering their ability to defend their clients. Again, you know, you've got people complaining to the bar about these attorneys right now. And as you know, that is just a distraction, hindering them from doing their job to protect their clients with these false accusations, these frivolous accusations. So his concern of retribution was brought to the court. Mrs. Baggio talked about the mechanism of discovery, and the obligation of the government is to provide that discovery. Third-party search support and conferences were being looked at closer. A third-party vendor is being identified right now. So does the defense need to have discovery? I don't know what that, okay, never mind that note. Government must produce discovery ASAP. Okay, so she says the government must produce the discovery ASAP in order, so the judge concedes with both Michael Arnold and Amy Baggio. Judge has agreed to all retention reviews for Pete Santilli and everything to go over to Judge Jones. So Judge Jones, I don't know his first name yet, but I got to see him in court today with Jason Blomgren. Judge Jones is going to oversee all the remaining retention reviews. And those people are Fry, Santilli, Patrick. Santilli and Jason Patrick, I think, are on Friday, by the way. Judge Jones won't be there on Friday because he wasn't available that short notice for Friday. So there will be another judge reviewing Pete Santilli's on Friday. All reviews for detention release will be Judge Jones after that, though, for sure. Government dismiss indictments. Okay, so there's something going on with the Cooper case. I need to make some calls on that. I can't even pretend to understand what they were talking about because they were speaking in code. Government is intruding.
I believe what happened is that he was in charge of another indictment in another court.
Yeah.
What they've done is they joined it.
Okay, so
Instead of maintaining it separately, he maintained all of these motions that he's filed in that court, all of these rights that he's maintained in that court. They just join it into this single case.
okay, so all the rights and everything. He there's another case in another court, and they're trying to get all his rights. What he's saying is all his rights to be released and orders to be released to be able to be handled in this court adequately by filing his motions and his hearings. I hope that's all it means. That sounds fine if that's what it is. I honestly was confused though.
They joined the separate.
Okay, so they're joining a separate case. They're joining it in one is what they're doing. And they call it the Cooper case. But honestly, that's what they've been doing for everybody. So maybe that's why I've been confused. Maybe because Cooper's is just getting on board with everybody else. And they were still working on that. Maybe that's what that is, all that was. So 2 rounds of motions should be their goal, the judge said, to the defendants and the prosecution. 2 rounds of motions, each motion to go 2 rounds and try and make that your goal. Be ready to back your motions up. 2 weeks for pre-trial motions from today. So we have a date, status hearing date, instead of monthly like it's supposed to be for some reason. And there's so many attorneys are going to be in France, attorneys are going to be vacationing somewhere else in the world. So there was really hard to pin it down. Judge wasn't going to be there for one of the dates. So finally they pinned down the next status hearing for June 15th, Wednesday at 09:30 in courtroom number 13, most likely. She talked about how that was preferable. And that's it. Ta-da.
June? Really? June?
Yep. But that's for, now remember, that's not a trial. That is a status hearing, meaning, are we doing well at moving forward?
Apparently, if they're doing a status hearing in June, they're not doing well at moving forward.
I agree with you. I had the same thoughts. I was very confused when I was writing that down. I said, June, they're supposed to do it monthly. Remember the first Wednesday of every month? That's what the original goal was at the 24th hearing. And I guess now we're going to skip a few months.
Yeah, I can't remember the exact case. It's been a couple of years ago, but I was watching this case between the federal government and some protester, and they literally kept this dude in jail for 4.5 years and waited until 8 days before statute of limitations ran out to actually try his case, in which everybody forgot about the whole damn thing.
Mm-hmm. Mm-hmm.
But anyway, let's move on into something else. And I don't know if you can help me with this. I put out the Shauna Cox video as well as everybody and their mother yesterday. I don't know if you can help me get in contact with her, but I would like to, if she's interested, to come on here and talk with us. I don't interview. I just let people talk. You know that?
Oh, I know you do a great job letting me talk this whole time.
Exactly. But so, if you can help me get in touch with her, that would be great.
Oh.
But,
I'll try.
What is, you saw yesterday that bullshit FBI press conference, and then I went and put the video out after that. I don't know if you saw it.
I did. I shared it.
All right. So, not the just inside the cab video. Mm-hmm. And it was, it was traumatic, not just for the listener or the watcher, but and it had to be incredibly traumatic for everybody in that truck.
Mm-hmm.
So why did the FBI not release the entire video? They released their part of the video, and I guarantee you, Shauna Cox started filming the minute they got pulled over, and she didn't stop filming, when Victoria got out of the truck. So where is the rest of that video is what I want to know. So anyway,
well,
go.
May I add to that? What about the head camera video? What about those videos? What about the body cams and the helmet cams?
Yeah, we know they're there.
And
We
the
know
dash
that.
cams.
Yeah,
Mm-hmm. Yeah, where is all that? And why is it being released in little tiny bits and pieces?
yeah, and I've had a ton of people say or tell me and show me that they have filed FOIA, Freedom of Information Act release, and they get denied every time. All
Right.
denied.
And my other concern is, in regards to this releasing and bits and things like that, and when you have all these body cams and other things like that, again, we already see that the government looking pretty suspicious. But why would they not only withhold these things, but why are they trying so hard to sell a false narrative to the public? They're tainting the jury pool. That's why.
Yep.
They're tainting the jury pool against these guys by causing the confusion. Even if we're catching them in a few lies, the public, they're fickle people. They want it, especially when the public has its own agenda. Many individuals have their own agenda, like the biodiversity group who has it out for the Bundys, when they have their own agenda, they'll take the mistakes the FBI made, so-called. I'm just playing devil's advocate here by minimizing the outright outrageous bold-faced lies already coming out. And I'm minimizing it to saying a mistake because, you can be sure that groups out there like that are going to ignore those facts and still buy and latch on to the false narrative, the false agenda, in order to prosecute and persecute innocent human beings just because they don't like them.
It's like the images they released of the inside of the boy's jacket.
Oh, the images, yeah.
I don't care who you are. A Derringer would not fit into that pouch.
Yeah, that looked like that was hard to stuff that weapon in that pocket, don't you think? That little white flimsy pocket inside the jacket.
Yeah, exactly. And we know that LeBoy had, and like I said, LeBoy had he had a shoulder holster. We know that. So the fact that they were trying to say it was in that pocket is complete and total BS.
And you have a right back bullet entry wound that exits out the left side. Yeah, he was grabbing his left side.
As I was saying, and I have found it endlessly interesting that this weapon did not come to light until after they got David Fry off of the refuge.
Remember something else too. Look at those images, people, the still photos of the AR-15 underneath the seat. Look real closely at how disgusting that truck looked. The black and charred areas from the gas canisters that were shot into the vehicle, crashing through windows with glass all over. Not only was there things charred and blackened and burn and paper strewn everywhere, but those weapons were pristine without even glass shattered and sprinkled onto the weapon.
Oh yeah, and they were all under the seats. It wasn't like anybody was shooting anything.
The seats. If you look under the seats when they lifted it, you can still see the destruction of the vehicle on the floor around the weapon and under the weapon. But yet the weapon had none of that mess on top of itself.
Right, exactly. Can you anyway, I asked a question earlier and I had to step away. Can you help me get Shauna Cox?
Oh, you want her now?
No, not right now, but at some point, if she could. If right now, that's fine, but I know she's going on Newsmax right now, so there's no way we're going to bring her on right now, so.
Yeah, I'd have to prepare better for her. Yeah, I can definitely, I'll give her a ring and see if she's up to it. I'm sure she would. She wants all the information out.
Yeah, that's cool. When I try to run Newsmax information, I always get a copyright strike. They always file a copyright strike from Newsmax if I put anything that is Newsmax up, so I've had to stop doing that, which sucks.
Yeah, for sure. Sorry. I'm a patriot, so I'm having my snacks right now.
Yeah, there you go. All right. Well, Mo, thank you very much. We needed this update, and it was very important that we all got to hear this. And I'm going to return you to your life and
I got
get some sleep, get some food, and
Ah!
get you get you some damn snacks and all that kind of stuff.
I got the snacks down.
They should sleep when we're dead.
Yeah, if we sleep, we die. No, I'm just kidding. Okay.
Yeah, you know what? People give me, recently people have been giving me crap because my videos are so long.
Oh, well. I'm still sharing it.
There you go. Talk to you later. Peace out.
Together. Out here.
Bye-bye.
Bye. Bye.
All right, so there you go. That was the gist of that.